Joined the Marines and led a rifle platoon in Vietnam, where you earned a Bronze Star, Purple Heart, and other commendations. You served as an assistant United States attorney leading the homicide unit here in D.C., U.S. attorney for the District of Massachusetts and later Northern District of California, assistant attorney general for DOJ's criminal division, and the FBI director. So thank you. I appreciate that. But having reviewed your biography, it puzzles me why you handled your duties in this case the way you did. The report contradicts what you taught young attorneys at the Department of Justice, including to ensure that every defendant is treated fairly, or as Justice Sutherland said in the Berger case, a prosecutor is not the representative of an ordinary party to a controversy, but of a sovereignty, whose interest in a criminal prosecution is not that it shall win a case, but that justice shall be done, and that the prosecutor may strike hard blows, but he is not at liberty to strike foul ones. By listing the 10 factual situations and not reaching a conclusion about the merits of the case, you unfairly shifted the burden of proof to the president, forcing him to prove his innocence while denying him a legal forum to do so. And I've never heard of a prosecutor declining a case and then holding a press conference to talk about the defendant. You noted 8 times in your report that you had a legal duty under the regulations to either prosecute or decline charges. Despite this, you disregarded that duty. As a former prosecutor, I'm also troubled with your legal analysis. You discussed 10 separate factual patterns involving alleged obstruction, and then you failed to separately apply the elements of the applicable statutes. I looked at the 10 factual situations, and I read the case law. And I have to tell you, just looking at the Flynn matter, for example, the 4 statutes that you cited for possible obstruction, 1503, 1505, 1512b3 and 1512c2. When I look at those concerning the Flynn matter, 1503 is inapplicable because there wasn't a grand jury or trial jury impaneled, and Director Comey was not an officer of the court as defined by the statute. Section 1505 criminalizes acts that would obstruct or impede administrative proceedings as those before Congress or an administrative agency. The Department of Justice Criminal Resource Manual states that the FBI investigation is not a pending proceeding. 1512b3 talks about intimidation, threats of force to tamper with a witness. General Flynn at the time was not a witness, and certainly Director Comey was not a witness. And 1512c2 talks about tampering with a record. And as Joe Biden described the statute as being debated on the Senate floor, he called this a statute criminalizing document shredding, and there's nothing in your report that alleges that the president destroyed any evidence. So what I have to ask you, and what I think people are working around in this hearing is, let me lay a little foundation for it. The ethical rules require that a prosecutor have a reasonable probability of conviction to bring a charge. Is that correct?
Sounds generally accurate.
Okay. And the regulations concerning your job as special counsel state that your job is to provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by your office. You recommended declining prosecution of President Trump and anyone associated with his campaign because there was insufficient evidence to convict for a charge of conspiracy with Russian interference in the 2016 election. Is that fair?
That's fair.
Was there sufficient evidence to convict President Trump or anyone else with obstruction of justice?
We did not make that calculation.
How could you not have made the calculation with the regulation?
The OLC opinion, Office of Legal Counsel, indicates that we cannot indict a sitting president. So one of the tools that a prosecutor would use is not there.
Okay, but let me just stop. You made the decision on the Russian interference. You couldn't have indicted the president on that, and you made the decision on that. But when it came to obstruction, you threw a bunch of stuff up against the wall to see what would stick. Well, and that is fundamentally unfair.
I would not agree to that characterization at all. What we did is provide to the Attorney General in the form of a confidential memorandum our understanding of the case, those cases that were brought, those cases that were declined, and that one case where the president cannot be charged with a crime.
Okay, but could you charge the president with a crime after he left office?
Yes.
You believe that you could charge the president of the United States with obstruction of justice after he left office?
Yes.
Ethically, under the ethical standards?
Well, I'm not certain because I haven't looked at the ethical standards, but the OLC opinion says that the prosecutor, while he cannot bring a charge against the sitting president, nonetheless he can continue the investigation to see if there are any other persons who might be drawn into the conspiracy.
Time of the gentleman has expired. The gentleman from Rhode Island.
Director, as you know, we are specifically focusing on 5 separate obstruction episodes here today. I'd like to ask you about the third episode. It's the section of your report entitled "The President's Efforts to Curtail the Special Counsel Investigation," beginning at page 90. And by curtail, you mean limit, correct?
Correct.
My colleagues have walked through how the President tried to have you fired through the White House counsel, and because Mr. McGahn refused the order, the President asked others to help limit your investigation. Is that correct?
Correct.
And was Corey Lewandowski one such individual?
And again, can you remind me what character?
Well, Corey Lewandowski is the President's former campaign manager, correct?
Correct.
Did he have any official position in the Trump administration?
I don't believe so.
Your report describes an incident in the Oval Office involving Mr. Lewandowski on June 19, 2017, at volume 2, page 91. Is that correct?
I'm sorry, what's the citation, sir?
Page 91.
Of the second volume?
Yes.
And
A meeting in the Oval Office between Mr. Lewandowski and the President.
Okay.
And that was just 2 days after the President called Don McGahn at home and ordered him to fire you. Is that correct?
Apparently so.
So right after his White House counsel, Mr. McGahn, refused to follow the President's order to fire you, the President came up with a new plan. And that was to go around all of his senior advisors and government aides to have a private citizen try to limit your investigation. What did the President tell Mr. Lewandowski to do? Do you recall he told him, he dictated a message to Mr. Lewandowski for Attorney General Sessions and asked him to write it down. Is that correct?
True.
And did you and your team see this handwritten message?
I'm not going to get into what we may or may not have included in our investigation.
Okay, the message directed Sessions to give, and I'm quoting from your report, to give a public speech saying that he planned to meet with the special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election meddling for future elections. That's at page 91. Is that correct?
Yes, I see that. Thank you. Yes, it is.
In other words, Mr. Lewandowski, a private citizen, was instructed by the President of the United States to deliver a message from the President to the Attorney General that directed him to limit your investigation, correct?
Correct.
And at this time, Mr. Sessions was still recused from oversight of your investigation, correct?
I'm sorry, could you restate
The Attorney
that?
General was recused from oversight.
Yes.
So the Attorney General would have had to violate his own department's rules in order to comply with the President's order, correct?
Well, I'm not going to get into the subsidiary details.
Okay.
I just refer you again to page 91, 92 of the report.
And if the Attorney General had followed through with the President's request, Mr. Mueller, it would have effectively ended your investigation into the President and his campaign, as you note on page 97, correct?
Could you
At page 97, you write, and I quote, "Taken together, the President's directives indicate that Sessions was being instructed to tell the special counsel to end the existing investigation into the President and his campaign, with the special counsel being permitted to move forward with investigating election meddling for future elections." Is that correct?
Generally true. Yes, sir.
And an unsuccessful attempt to obstruct justice is still a crime. Is that correct?
That is correct.
And Mr. Lewandowski tried to meet with the Attorney General. Is that right?
True.
And he tried to meet with them in his office so he would be certain there wasn't a public log of the visit.
According to what we gathered for the report.
And the meeting never happened, and the President raised the issue again with Mr. Lewandowski, and this time he said, and I quote, "If Sessions does not meet with you, Lewandowski should tell Sessions he was fired." Correct?
Correct.
So immediately following the meeting with the President, Lewandowski then asked Mr. Dearborn to deliver the message, who's the former Chief of Staff to Mr. Sessions, and Mr. Dearborn refuses to deliver it because he doesn't feel comfortable. Isn't that correct?
Generally correct, yes.
So just so we're clear, Mr. Mueller, 2 days after the White House counsel, Don McGahn, refused to carry out the President's order to fire you, the President directed a private citizen to tell the Attorney General of the United States, who was recused at the time, to limit your investigation to future elections, effectively ending your investigation into the 2016 Trump campaign. Is that correct?
I'm not going to adopt your characterization. I'll say that the facts as laid out in the report are accurate.
Well, Mr. Mueller, in your report, you in fact write at page 97, Substantial evidence indicates that the president's effort to have Sessions limit the scope of the special counsel's investigation to future elections interference was intended to prevent further investigative scrutiny of the president and his campaign conduct. Is that correct?
Generally.
And so, Mr. Mueller, you have seen the letter where 1,000 former Republican and Democratic federal prosecutors have read your report and said anyone but the president who committed those acts would be charged with obstruction of justice. Do you agree with those former colleagues, 1,000 prosecutors who came to that conclusion?
Those prosecutors.
Thank you, Mr. Chairman. Over here. Thanks. Mr. Mueller, you guys, your team wrote in the report, quote, this is the top of page 2, volume 1, also on page 173, by the way. You said that you'd come to the conclusion that, quote, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities, close quote. That's an accurate statement, right?
That's accurate.
And I'm curious, when did you personally come to that conclusion?
Can you remind me which paragraph you're referring to?
Top of page 2.
On 2?
Volume 1.
Okay. And exactly which paragraph are you looking at on 2?
Investigation did not establish.
Of course. I see it. Yes.
See it?
What was your question?
My question now is, when did you personally reach that conclusion?
Well, we were ongoing for 2 years.
Right, you were ongoing, you wrote it at some point during that 2-year period, but at some point you had to come to a conclusion that that I don't think there's not a conspiracy going on here. There was no conspiracy between this president. I'm not talking about the rest of the president's team. I'm talking about this president and the Russians.
As you understand, developing a criminal case, you get pieces of information, witnesses, and the like, as you make your case.
Right.
And when you make a decision on a particular case depends on a number of factors.
Right, I understand
So I
all
cannot
this.
say specifically that we reached a decision on a particular defendant at a particular point in time.
But it was some time well before you wrote the report, fair enough? I mean, you wrote the report dealing with a whole myriad of issues. Certainly at some time prior to that report is when you reached the decision that, okay, with regard to the president himself, I don't find anything here. Fair enough?
Well, I'm not certain I do agree with that.
So you waited till the last minute when you were actually writing the report and say, oh, okay.
No, but there are various aspects of a development of
Sure, and that's my point. There are various aspects that happen, but somewhere along the pike, you will come to a conclusion. There's no there for this defendant. Isn't that right? So apparently,
I can't speak.
You can't say when. Fair enough. So you know, I'm asking the sworn witness. Mr. Mueller, evidence suggests that on May 10th, 2017, at approximately 7:45 a.m., 6 days before the DAG Deputy Attorney General appointed you special counsel, Mr. Rosenstein called you and mentioned the appointment of a special counsel. Not necessarily that you'd be appointed, but that you had a discussion of that. Is that true? May 10th, 2017.
I don't have any. I don't have any knowledge of that occurring.
You don't have any knowledge, or you don't recall?
I don't have any knowledge.
Evidence also suggests.
I mean, given that what I saw you do, are you questioning that?
Well, I just find it intriguing. Let me just tell you that there's evidence that suggests that phone call took place and that that's what was said. So let's move to the next question. Evidence suggests that also on May 12th, 2017, 5 days before the DAG appointed you special counsel, you met with Mr. Rosenstein in person. Did you discuss the appointment of a special counsel then? Not necessarily that you, but that there would be a special counsel.
I've gone into waters that don't allow me to give you an answer to that particular question. It relates to the internal discussions he would have in terms of indicting an individual.
It has nothing to do with indictment. It has to do with special counsel and whether you discussed that with Mr. Rosenstein. Evidence also suggests that on May 13th, 4 days before you were appointed special counsel, you met with former Attorney General Sessions and Rosenstein, and you spoke about special counsel. Do you remember that?
Not offhand, no.
Okay. And on May 16th, the day before you were appointed special counsel, you met with the president and Rod Rosenstein. Do you remember having that meeting?
Yes.
And discussion of the position of FBI director took place. Do you remember that?
Yes.
And did you discuss at any time in that meeting Mr. Comey's termination?
No.
Did you discuss at any time in that meeting the potential appointment of a special counsel? Not necessarily you, but just in general terms.
I can't get into the discussions on that.
How many times did you speak to Mr. Rosenstein before May 17th, which is the day you got appointed, regarding the appointment of special counsel? How many times prior to that did you discuss?
I can't tell
with
you
him?
how many times.
Is that because you don't recall, or are you just?
I do not recall.
Okay, thank you. How many times did you speak with Mr. Comey about any investigations pertaining to Russia prior to May 17, 2017? Did you have any?
Not at all.
Zero?
Zero.
Okay. Now, my time has expired, so.
Time of the gentleman has expired. The gentleman from California.
Director Mueller, going back to the president's obstruction via Corey Lewandowski, it was referenced that 1,000 former prosecutors who served under Republican and Democratic administrations with 12,000 years of federal service wrote a letter regarding the president's conduct. Are you familiar with that letter?
I've read about that letter, yes.
And some of the individuals who signed that letter, the statement of former prosecutors, are people you worked with. Is that right?
Quite probably, yes.
People that you respect?
Quite probably, yes.
And in that letter, they said all of this conduct, trying to control and impede the investigation against the president by leveraging his authority over others, is similar to conduct we have seen charged against other public officials and people in powerful positions. Are they wrong?
They have a different case.
Do you want to sign that letter, Director Mueller?
They have a different case.
Director Mueller, thank you for your service, going all the way back to the 60s when you courageously served in Vietnam. Because I have a seat on the Intelligence Committee, I'll have questions later. And because of our limited time, I will ask to enter this letter into the record under unanimous consent.
Without
and yield to
objection.
my colleague from California, Mr. Liu.
Thank you, Director Mueller, for your long history of service to our country, including your service as a Marine, where you earned a Bronze Star with a V device. I'd like to now turn to the elements of obstruction of justice as applied to the President's attempts to curtail your investigation. The first element of obstruction of justice requires an obstructive act, correct?
Correct.
Okay, I'd like to direct you to page 97 of Volume 2 of your report. And you wrote there on page 97, quote, Sessions was being instructed to tell the special counsel to end the existing investigation into the president and his campaign, unquote. That's in the report, correct?
Correct.
That would be evidence of an obstructive act because it would naturally obstruct their investigation, correct?
Correct.
Okay. Let's turn now to the second element of the crime of obstruction of justice, which requires a nexus to an official proceeding. Again, I'm going to direct you to page 97, the same page of Volume 2, and you wrote, quote, by the time of the President's initial one-on-one meeting with Lewandowski on June 19, 2017, the existence of a grand jury investigation supervised by the special counsel was public knowledge. That's in the report, correct?
Correct.
That would constitute evidence of a nexus to an official proceeding because a grand jury investigation is an official proceeding, correct?
Well, yes.
Okay. I'd like to now turn to the final element of the crime of obstruction of justice. On that same page, page 97, do you see where there's the intent section on that page?
I do see
Subpart
that.
C. All right. Would you be willing to read the first sentence?
And that was starting with
Substantial evidence.
indicates that the president's.
Yeah, if you could read that first sentence, would you be willing to do that?
I'm happy to have you read it.
Okay, I will read it then. You wrote, quote, substantial evidence indicates that the president's effort to have Sessions limit the scope of the special counsel's investigation to future election interference was intended to prevent further investigative scrutiny of the president's and his campaign's conduct, unquote. That's in the report, correct?
That is in the report, and I rely what's in the report to indicate what's happened in the paragraphs that we've been discussing.
Thank you. So to recap what we've heard, we have heard today that the president ordered former White House counsel Don McGahn to fire you. The president ordered Don McGahn to then cover that up and create a false paper trail. And now we've heard the president ordered Corey Lewandowski to tell Jeff Sessions to limit your investigation so that you stop investigating the president. I believe a reasonable person looking at these facts could conclude that all three elements of the crime of obstruction of justice have been met. And I'd like to ask you, the reason, again, that you did not indict Donald Trump is because of OLC opinion stating that you cannot indict a sitting president, correct?
That is correct.
The fact that their orders by the president were not carried out, that is not a defense to obstruction of justice because the statute itself is quite broad. It says that as long as you endeavor or attempt to obstruct justice, that would also constitute a crime.
I'm not going to get into that at this juncture.
Okay, thank you. And based on the evidence that we have heard today, I believe a reasonable person could conclude that at least 3 crimes of obstruction of justice by the president occurred. We're going to hear about 2 additional crimes. That would be the witness tamperings of Michael Cohen and Paul Manafort.
All that,
I yield back.
the only thing I want to add is that I'm going through the elements with you does not mean that I subscribe to what you're trying to prove through those elements.
The time of the gentleman has expired. The gentlelady from Arizona. I'm sorry, gentleman from California.
Thank you, Mr. Chairman. Mueller, over here. Thanks for joining us today. You had 3 discussions with Rod Rosenstein about your appointment as special counsel, May 10th, May 12th, and May 13th, correct?
If you say so, I have no reason to dispute that.
Then you met with the president on the 16th with Rod Rosenstein present, and then on the 17th, you were formally appointed as special counsel. Were you meeting with the president on the 16th with knowledge that you were under consideration for appointment to special counsel?
I did not believe I was under consideration for counsel. I had served 2 terms as FBI
Okay,
director,
so the answer is no.
and the answer is no.
Greg Jarrett describes your office as the team of partisans. And as additional information is coming to light, there's a growing concern that political bias caused important facts to be omitted from your report in order to cast the president unfairly in a negative light. For example, John Dowd, the president's lawyer, leaves a message with Michael Flynn's lawyer on November 17th of 2017, November 2017. The edited version in your report makes it appear that he was improperly asking for confidential information, and that's all we know from your report, except that the judge in the Flynn case ordered the entire transcript released, in which Dowd makes it crystal clear that's not what he was suggesting. So my question is, why did you edit the transcript to hide the exculpatory part of the message?
Well, I'm not certain I would agree with your characterization as that we did anything to hide.
Well, you omitted it. You quoted the part where he says we need some kind of heads up just for the sake of protecting all of our interests if we can, but you omitted the portion where he says without giving up any confidential information.
Well, I'm not going to go further in terms of discussing the...
Well, let's go on. You extensively discussed Konstantin Kilimnik's activities with Paul Manafort. You describe him as, quote, a Russian-Ukrainian political consultant and longtime employee of Paul Manafort, assessed by the FBI to have ties to Russian intelligence. And again, that's all we know from your report, except we've since learned from news articles that Kilimnik was actually a U.S. State Department intelligence source, yet nowhere in your report is he so identified. Why was that fact?
I don't necessarily credit what you're saying occurred.
Were you aware that Kilimnik was
I'm not going to go into the ins and outs. I'm not going to go into the ins and outs of what we had in the court. In the course of our investigation.
Did you interview Konstantin Kilimnik?
Pardon?
Did you interview Konstantin Kilimnik?
I can't go into the discussion of our investigative moves.
And yet that is the basis of your report. Again, the problem we're having is we have to rely on your report for an accurate reflection of the evidence, and we're starting to find out that's not true. For example, your report famously links Russian internet troll farms with the Russian government. Yet at a hearing on May 28th in the Concord Management IRA prosecution that you initiated, the judge excoriated both you and Mr. Barr for producing no evidence to support this claim. Why did you suggest Russia was responsible for the troll farms when in court you've been unable to produce any evidence to support it?
Well, I'm not going to get into that any further than I already have.
But you have left the clear impression throughout the country through your report that it was the Russian government behind the troll farms, and yet when you're called upon to provide actual evidence in court, you fail to do so.
Well, I would again dispute your characterization of what occurred in that proceeding.
In fact, the judge, considered holding prosecutors in criminal contempt. She backed off only after your hastily called press conference the next day, in which you retroactively made the distinction between the Russian government and the Russia troll farms. Did your press conference of May 29th have anything to do with the threat to hold your prosecutors in contempt the previous day for publicly misrepresenting the evidence?
What was the question?
The question is, did your May 29th press conference have anything to do with the fact that the previous day the judge threatened to hold your prosecutors in contempt for misrepresenting evidence?
No.
Now, the fundamental problem is, as I said, we've got to take your word. Your team faithfully, accurately, impartially, and completely described all of the underlying evidence in the Mueller report. And we're finding more and more instances where this just isn't the case. And it's starting to look like, having desperately tried and failed to make a legal case against the president, you made a political case instead. You put it in a paper sack, lit it on fire, dropped it on our porch, rang the doorbell, and ran.
I don't think you reviewed a report that is as thorough, as fair, as consistent as the report that we have in front of us.
Then why is
The
contradictory
time of the gentleman
information
is
continuing
expired.
to
The
come out?
gentleman from Maryland is recognized.
Director Mueller, let's go to a fourth episode of obstruction of justice in the form of witness tampering, which is urging witnesses not to cooperate with law enforcement, either by persuading them or intimidating them. Witness tampering is a felony punishable by 20 years in prison. You found evidence that the president engaged in efforts, and I quote, to encourage witnesses not to cooperate with the investigation. Is that right?
That's correct. Do you have a citation?
I'm page 7 on volume 2.
Thank you.
Now, one of these witnesses was Michael Cohen, the president's personal lawyer, who ultimately pled guilty to campaign violations based on secret hush money payments to women the president knew, and also to lying to Congress about the hoped-for $1 billion Trump Tower deal. After the FBI searched Cohen's home, the president called him up personally, he said, to check in, and told him to, quote, hang in there and stay strong. Is that right? Do you remember finding that?
If it's in the report as stated, yes, it is right.
Yes, also in the report, actually, are a series of calls made by other friends of the president. One reached out to say he was with the boss in Mar-a-Lago, and the president said, he loves you. His name is redacted. Another redacted friend called to say, the boss loves you, and a third redacted friend called to say, everyone knows the boss has your back. Do you remember finding that sequence of calls?
Generally, yes.
When the news, and in fact, Cohen said that following the receipt of these messages, I'm quoting here, page 147 of volume 2, he believed he had the support of the White House if he continued to toe the party line, and he determined to stay on message and be part of the team. That's at page 147. Do you remember generally finding that?
Generally, yes.
Well, Robert Costello, a lawyer close to the president's legal team, emailed Cohen to say, quote, you are loved, they are in our corner, sleep well tonight, and you have friends in high places. And that's up on the screen, page 147. You remember reporting that. Okay. Now, when the news first broke that Cohen had arranged payoffs to Stormy Daniels, Cohen faithfully stuck to this party line. He said that publicly that neither the Trump Organization nor the Trump campaign was a party to the transaction, and neither reimbursed him. Trump's personal attorney at that point quickly texted Cohen to say, quote, client says thank you for what you do. Mr. Mueller, who is the capital C client thanking Cohen for what he does?
I can't speak to that.
Okay, the assumption in the context suggests very strongly it's President Trump.
I can't speak to that.
Okay. Cohen later broke and pled guilty to campaign finance offenses and admitted fully they were made, quote, at the direction of candidate Trump. Do you remember that?
Yes.
After Cohen's guilty plea, the president suddenly changed his tune towards Mr. Cohen, didn't he?
I would say I rely on what's in the report.
Well, he made the suggestion that Cohen family members had committed crimes. He targeted, for example, Cohen's father-in-law and repeatedly suggested that he was guilty of committing crimes, right?
Generally accurate.
Okay. On page 154, you give a powerful summary of these changing dynamics. And you said, I'm happy to have you read it, but I'm happy to do it if not.
I have it in front of me. Thank you.
Would you like to read it?
I would.
Can you read it out loud to everybody?
I would be happy to have you read it out.
Okay, fair. We'll read it at the same time. The evidence concerning this sequence of events could support an inference that the president used inducements in the form of positive messages in an effort to get Cohen not to cooperate, and then turned to attacks and intimidation to deter the provision of information or to undermine Cohen's credibility once Cohen began cooperating.
I believe that's accurate.
Okay, and in my view, if anyone else in America engaged in these actions, they would have been charged with witness tampering. We must enforce the principle in Congress that you emphasize so well in the very last sentence of your report, which is that in America, no person is so high as to be above the law. I yield back, Mr. Chairman.
Thank you, Mr. Chairman. Just recently, Mr. Mueller, you said Mr. Liu was asking you questions. And Mr. Liu's question, I quote, "The reason you didn't indict the president is because of the OLC opinion." And you answered, "That is correct." But that is not what you said in the report, and it's not what you told Attorney General Barr. And in fact, in a joint statement that you released with DOJ on May 29th, after your press conference, your office issued a joint statement with the Department of Justice that said, "The Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying that but for the OLC opinion, he would have found the president obstructed justice. The special counsel's report and his statement today made clear that the office concluded it would not reach a determination one way or the other whether the president committed a crime. There is no conflict between these statements." So, Mr. Miller, do you stand by your joint statement with DOJ that you issued on May 29th as you sit here today?
I would have to look at it more closely before I said I agree with it.
Well, my conclusion is that what you told Mr. Liu really contradicts what you said in the report, and specifically what you said apparently repeatedly to Attorney General Barr, and then you issued a joint statement on May 29th saying that the Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying but for the OLC report that we would have found the president obstructed justice. So I just say there's a conflict. I do have some more questions. Mr. Mueller, there's been a lot of talk today about firing the special counsel and curtailing the investigation. Were you ever fired, Mr. Mueller, from the special?
What?
Were you ever fired as special counsel, Mr. Mueller?
No.
No. Were you allowed to complete your investigation unencumbered?
Yes.
And in fact, you resigned as special counsel when you closed up the office in late May 2019. Is that correct?
That's correct.
Thank you. Mr. Mueller, on April 18th, the Attorney General held a press conference in conjunction with the public release of your report. Did Attorney General Barr say anything inaccurate, either in his press conference or his March 24th letter to Congress summarizing the principal conclusions of your report?
Well, what you are not mentioning is a letter we sent on March 27th to Mr. Barr that raised some issues. And that letter speaks for itself.
But then I don't see how you that could be, since AG Barr's letter detailed the principal conclusions of your report, and you have said before that there wasn't anything inaccurate. In fact, you had this joint statement. But let me go on to another question. Mr. Mueller, rather than purely relying on the evidence provided by witnesses and documents, I think you relied a lot on media. I'd like to know how many times you cited the Washington Post in your report.
How many times I what?
Cited the Washington Post in your report.
I do not have knowledge of that figure, but Well, that's it. I don't have knowledge of that figure.
I counted about 60 times. How many times did you cite the New York Times? I counted.
Again, I have no idea.
I counted about 75 times. How many times did you cite Fox News?
As with the other two, I have no idea.
About 25 times. I've got to say, it looks like Volume 2 is mostly regurgitated press stories. Honestly, there's almost nothing in Volume 2 that I couldn't already hear or know simply by having a $50 cable news subscription. However, your investigation cost the American taxpayers $25 million. Mr. Mueller, you cited media reports nearly 200 times in your report. Then in a footnote, a small footnote, number 7, page 15 of volume 2 of your report, you wrote, I quote, "This section summarizes and cites various news stories, not for the truth of the information contained in the stories, but rather to place candidate Trump's response to those stories in context. Since nobody but lawyers reads footnotes, are you concerned that the American public took the embedded news stories at
Time of the
face value?"
gentlelady has expired. The gentlelady from Washington.
Can Mr. Mueller
No.
answer the question?
No, we're running short on time. I said the gentlelady from Washington.
Thank you. Director Mueller, let's turn to the 5th of the obstruction episodes in your report, and that is the evidence of whether President Trump engaged in witness tampering with Trump campaign chairman Paul Manafort, whose foreign ties were critical to your investigation into Russia's interference in our elections. And this starts at volume 2, page 123. Your office got indictments against Manafort and Trump deputy campaign manager Rick Gates in 2 different jurisdictions, correct?
Correct.
And your office found that after a grand jury indicted them, Manafort told Gates not to plead guilty to any charges because, quote, he had talked to the president's personal counsel and they were going to take care of us. Is that correct?
That's accurate.
And according to your report, one day after Manafort's conviction on 8 felony charges, quote, the president said that flipping was not fair and almost ought to be outlawed. Is that correct?
I'm aware of that.
In this context, Director Mueller, what does it mean to flip?
Have somebody cooperate in a criminal investigation.
And how essential is that cooperation to any efforts to combat crime?
I'm not going to go beyond that, characterizing that
Thank you.
effort.
In your report, you concluded that President Trump and his personal counsel, Rudy Giuliani, quote, made repeated statements suggesting that a pardon was a possibility for Manafort, while also making it clear that the president did not want Manafort to flip and cooperate with the government, end quote. Is that correct?
Correct.
And as you stated earlier, witness tampering can be shown where someone with an improper motive encourages another person not to cooperate with law enforcement. Is that correct?
Correct.
Now, on page 123 of volume 2, you also discuss the president's motive, and you say that as court proceedings move forward against Manafort, President Trump, quote, discussed with aides whether and in what way Manafort might be cooperating and whether Manafort knew any information that would be harmful to the president, end quote. Is that correct?
And that was a quote from?
From page 123, volume 2.
I have it. Thank you. Yes.
And when someone tries to stop another person from working with law enforcement and they do it because they're worried about what that person will say, it seems clear from what you wrote that this is a classic definition of witness tampering. Now, Mr. Manafort did eventually decide to cooperate with your office and he entered into a plea agreement, but then he broke that agreement. Can you describe what he did that caused you to tell the court that the agreement was off?
I refer you to the court proceedings on that issue.
So on page 127 of volume 2, you told the court that Mr. Manafort lied about a number of matters that were material to the investigation, and you said that the Manafort's lawyers also, quote, regularly briefed the president's lawyers on topics discussed and the information that Manafort had provided in interviews with the special counsel's office. Does that sound right?
And the source of that is?
That's page 127, volume 2. That's a direct quote.
If it's from the report, yes, I support it.
And 2 days after you told the court that Manafort broke his plea agreement by lying repeatedly, did President Trump tell the press that Mr. Manafort was, quote, very brave because he did not flip? This is page 128 of volume 2.
If it's in the report, I support it as it is set forth.
Thank you. Director Mueller, in your report, you make a very serious conclusion about the evidence regarding the president's involvement with the Manafort criminal proceedings. Let me read to you from your report. Evidence concerning the president's conduct toward Manafort indicates that the president intended to encourage Manafort to not cooperate with the government. It is clear that the president both publicly and privately discouraged Mr. Manafort's cooperation or flipping, while also dangling the promise of a pardon if he stayed loyal and did not share what he knew about the president. Anyone else who did these things would be prosecuted for them. We must ensure that no one is above the law. And I thank you for being here, Director Mueller. Yield back.
Gentleman from Pennsylvania.
Thank you, Mr. Chairman. Mr. Mueller, I'm over here, I'm sorry. Mr. Mueller, are you familiar with the now expired independent counsel statute? It's the statute under which Ken Starr was appointed.
That Ken Starr did what? I'm sorry.
Are you familiar with the independent counsel statute?
Are you talking about the one we operating under now or a previous?
No, under which Ken Starr was appointed?
I am not that familiar with that, but I'd be happy to take your question.
Well, the Clinton administration allowed the independent counsel statute to expire after Ken Starr's investigation. The final report requirement was a major reason why the statute was allowed to expire. Even President Clinton's AG, Janet Reno, expressed concerns about the final report requirement. And I'll quote AG Reno. She said, "On one hand, the American people have an interest in knowing the outcome of an investigation of their highest officials. On the other hand, the report requirement cuts against many of the most basic traditions and practices of American law enforcement. Under our system, we presume innocence and we value privacy. We believe that information obtained during a criminal investigation should, in most cases, be made public only if there is an indictment and prosecution, not in a lengthy and detailed report filed after a decision has been made not to prosecute. The final report provides a forum for unfairly airing a target's dirty laundry, and it also creates yet another incentive for an independent counsel to over-investigate in order to justify his or her tenure and to avoid criticism that the independent counsel may have left a stone unturned." Again, Mr. Mueller, those are AG Reno's words. Didn't you do exactly what AG Reno feared? Didn't you publish a lengthy report unfairly airing the target's dirty laundry without recommending charges?
I disagree with that.
Okay. Did any of your witnesses
Can I
have the
finish?
chance to be cross-examined?
Can I just finish my answer on that?
Quickly. My
I
time's
operate under the current statute, not the original
Okay.
statute. So I am most familiar with the current statute, not the older
Okay.
statute.
Did any of the witnesses have a chance to be cross-examined?
Did any of the witnesses in our investigation?
Yes.
I'm not going to answer that.
Okay. Did you allow the people mentioned in your report to challenge how they were characterized?
I'm not going to get into
Okay.
into that.
Given that AG Barr stated multiple times during his confirmation hearing that he would make as much of your report public as possible, did you write your report knowing that it would likely be shared with the public?
No.
Did knowing that the report could and likely would be made public, did that alter the contents which you included?
I can't speak to that.
Despite the expectations that your report would be released to the public, you left out significant exculpatory evidence. In other words, evidence favorable to the president, correct?
Well, I actually would disagree with you. I think we strove to put into the report exculpatory
I'm pretty sure
evidence as
Tom
well.
McClintock got into that with you, where he said you said there was evidence you left out.
Well, you make a choice as to what goes into
Isn't it
an
true,
indictment.
Mr. Mueller, isn't it true that on page 1 of volume 2, you state, when you're quoting the statute, that you had an obligation to either prosecute or not prosecute?
Well, generally that is the case.
Right.
Although most cases are not done in the context of the president.
And in this case, you made a decision not to prosecute, correct?
No, we made a decision not to decide whether to prosecute or not.
So essentially what your report did was everything that AG Reno warned against.
I can't agree with that
Okay.
characterization.
Well, what you did is you compiled nearly 450 pages of the very worst information you gathered against the target of your investigation, who happens to be the President of the United States. And you did this knowing that you were not going to recommend charges and that the report would be made public.
Not true.
Mr. Mueller, as a former officer in the United States JAG Corps, I prosecuted nearly 100 terrorists in a Baghdad courtroom. I cross-examined the butcher of Fallujah in defense of our Navy SEALs. As a civilian, I was elected a magisterial district judge in Pennsylvania, so I'm very well versed in the American legal system. The drafting and the publication of some of the information in this report without an indictment, without prosecution, frankly flies in the face of American justice. And I find those facts, this entire process, un-American. I yield the remainder of my time to my colleague, Jim Jordan.
Director Mueller, the third FISA renewal happens a month after you're named special counsel. What role did your office play in the third FISA renewal of Carter Page?
I'm not going to talk to that.
Time of the gentleman has expired. The gentlelady from Florida.
Director Mueller, a couple of my colleagues right here wanted to talk to you or ask you about lies. So let's talk about lies. According to your report, page 9, volume 1, witnesses lied to your office and to Congress. Those lies materially impaired the investigation of Russia interference, according to your report. Other than the individuals who pled guilty to crimes based on their lying to you and your team, did other witnesses lie to you?
I think there are probably a spectrum of witnesses in terms of those who are not telling the full truth, and those are outright liars.
Thank you very much. Outright liars. It is fair to say then that there were limits on what evidence was available to your investigation of both Russia election interference and obstruction of justice.
That's true, and it's usually the case.
And that lies by Trump campaign officials and administration officials impeded your investigation.
I would generally agree with that.
Thank you so much, Director Mueller. You will be hearing more from me in the next hearing, so I yield the balance of my time to Mr. Correa. Thank you.
Mr. Mueller, first of all, let me welcome you. Thank you for your service to our country. You're a hero, Vietnam War vet, wounded war vet. We won't forget your service to our country.
Thank you, sir.
I may begin. Because of time limits, we have gone in depth on only 5 possible episodes of obstruction. There's so much more. And I want to focus on another section of obstruction, which is the president's conduct concerning Michael Flynn, the president's national security advisor. In early 2017, the White House counsel and the president were informed that Mr. Flynn had lied to government authorities about his communications with the Russian ambassador during the Trump campaign and transition. Is this correct?
Correct.
If a hostile nation knows that a U.S. official has lied publicly, that can be used to blackmail that government official, correct?
I'm not going to speak to that. I don't disagree with it necessarily, but I'm not going to speak to any more to that issue.
Thank you very much, sir. Flynn resigned on February 13, 2016. And the very next day, when the president was having lunch with New Jersey Governor Chris Christie, did the president say, open quotes, "Now that we fired Flynn, the Russia thing is over," close quote. Is that correct?
Correct.
And is it true that Christie responded by saying, open quotes, "No way, and this Russia thing is far from over," close quote?
That's the way we have it in the report.
Thank you. And after President met with Christie, later that same day, the president arranged to meet with then FBI Director James Comey, alone in the Oval Office, correct?
Correct, particularly if you have the citation to the report.
Page 3940, Volume 2.
Thank you very much.
And according to Comey, the president told him, "I hope," open quote, "I hope you can see your way to letting this thing go, to letting Flynn go. He's a good guy, and I hope you can let it go," close quote. Page 40, Volume 2.
Accurate.
What did Comey understand the president to be asking?
I'm not going to get into what was in Mr. Comey's mind.
Comey understood this to be a direction because of the president's position and the circumstances of the one-to-one meeting. Page 40, Volume 2.
Well, I understand it's in the report, and I support it as being in the report.
Thank you, sir. Even though the president publicly denied telling Comey to drop the investigation, you found, open quote, substantial evidence corroborating Comey's account over the president's. Is this correct?
That's correct.
The president fired Comey on May 9th. Is that correct, sir?
I believe that's the accurate date.
That's page 77, volume 2. You found substantial evidence that the catalyst for the president's firing of Comey was Comey's, open quote, unwillingness to publicly state that the president was not personally under investigation.
I'm not going to delve more into the details of what happened. If it's in the report, then I'm supportive because it's already been reviewed and appropriately appears in the report.
And that's page 75, volume 2.
Thank you.
Thank you. And in fact, the very next day, the president told the Russian foreign minister, open quote, I just fired the head of the FBI. He was crazy, a real nut job. I face great pressure because of Russia. That's taken off. I'm not under investigation, close quote. Is that correct?
That's what was written in the report, yes.
Time of the gentleman has expired.
Thank you, sir.
Gentleman from Virginia.
Thank you, Mr. Chairman. Mr.